Thursday, February 25th, 2021. I'm looking at our agenda. The first item is an approval of minutes, and that will be the minutes from our last case, the Charles and Elizabeth Myers case. I am told the minutes are not yet completed, and we'll have to get to that at another time. So we will move on to various business matters. I have handed out to all of the board members a copy of the parts of the new North Carolina General Statute, Chapter 160D sections that are pertinent to us on this Board of Adjustment. And part of the rules, part of that new statute, is Section 160D-308, Rules of Procedure, and in it it says that if we as a board, may adopt our own rules and procedures that are inconsistent with the state and local law. But if we do adopt some of our own rules in addition to the others, we should list them, make a copy available to the clerk so she can hand them out to the public. And we're going to work on that right now and comply with that part of the new statute. The first thing I would like to do is make a motion to repeal a rule we adopted on January 28th, 2020 about scheduling of cases. It was long, it was convoluted, and it called on a lot of steps involving me as the chair of this board, with the planning director, and with anybody bringing business to the board. I'm going to make a motion that we repeal and do away with that resolution of pertaining to scheduling that we did on January 28th, 2020. I'm going to move to something that I think is a little bit more practical. I have made the motion, and is there a second for that motion?
Where is the motion?
Dr. Rockmore seconds the motion. As far as repealing the earlier scheduling resolution we did, is there any further discussion on that? Hearing none, that is repealed. Now, I have handed out to the board members something that starts at the top, resolved. And let me go ahead and bear with me. Let me verbally put it on the record. Resolved, because North Carolina General Statute 160D-308 requires that a board such as the Blowing Rock Board of Adjustment shall maintain with the local clerk a copy of its own adopted rules of procedure, and because posting of such local rules of procedure would also be helpful to those who have business before the Blowing Rock Board of Adjustment, the board hereby lists and publishes policies, rules, and procedures adopted by the board. Shown below are Blowing Rock Board of Adjustment policies, procedures, and rules adopted by the board pursuant to the authority granted in North Carolina General Statute 160D-308 and Blowing Rock Town Code Section 16-3.2.6.5, which says that we may adopt our own rules that aren't inconsistent with other higher law. These are in addition to all other rules and procedures required by local and state law. This list is to be reviewed and amended yearly. Any and all other such policy, rules, and procedures which are enacted in open and public meeting since the last updating of this list shall also apply and have full force and effect in the Board of Adjustments meeting and hearings. And we're going to need to take these and have a vote one by one. The first rule listed here would be a new scheduling rule, and it reads as follows. To assist in keeping with the town calendar, regular meetings of the Board of Adjustment will be held at 5:30 p.m. on the fourth Thursday of each month as needed for pending business. While the scheduling of meetings and hearings of the Board of Adjustment shall be held at the call of and under the control of the chair or vice chair as provided in Blowing Rock Town, section 16-3.2.2. The dates of meetings and hearings shall be determined by the chair or vice chair after consultation and coordination with all parties having upcoming business with the board, as well as with the members of the board, while reserving the authority of the board to have the last word on scheduled dates and times. The chair or vice chair shall make a good faith effort to consider and accommodate the scheduled demands and conflicts of all parties, witnesses, and board members. I'm going to make a motion that we adopt that resolution number 1 pertaining to scheduling. Do I have a second?
I have a question.
Yes, sir.
Do we need to put a timeline as to what is reasonable? I mean, obviously, things could get kept being postponed. Do we need to put a finite timeline that within, say, 2 months, 6 weeks, whatever, that there should be a finite timeline for what's considered reasonable?
I believe there's a Blowing Rock statute that says that we're going to handle these hearings in a fairly expedited, timely manner. And I'm hoping that we will honor that and we'll handle these in an expedited, timely manner. Let's don't tie our hands by putting.
Okay.
Let's trust ourselves to do the right thing.
Okay, I'm just asking. You know,
It's a great question, but I think we're going to do things in a very timely manner. I don't think we're going to keep the town or the applicants or the appellants waiting. I think we'll get to it. Chop, I really do.
Okay.
It just has a section here in Article 4, application to be processed expeditiously.
Correct.
Doesn't give anything, but there are some stipulations on other permits, 45 days, I think, but.
Well, on the hearings that we do, I think we can be trusted to realize that the applicants and the appellants, they want their day in court, so to speak. The town wants resolution, and the town citizens want them handled timely manner. I think we can be trusted to do it. Did we have a second?
No, and if you make a second or make a motion, if you'll please state your name, and that's kind of goes all night, so Tammy can pick it up for the minutes.
Okay, let's put that on the record. I'm having a blank. What's Tammy's last name?
Bentley.
Ms. Bennett?
Bentley.
Ms. Tammy, I apologize for forgetting your last name. Our town clerk, Hillary Huebner, ordinarily is here and keeps the minutes of our meetings. She is not here. An employee at the Planning and Zoning and Inspection Office, Ms. Tammy Bentley, is here with us by way of Zoom. She's going to keep the meeting minutes for tonight. All right, so I've made a motion to adopt that scheduling resolution number 1. Is there a second to that motion?
I make a second. Lance Campbell, Tammy.
Any further discussion on the scheduling resolution? Hearing none, all those in favor of adopting the scheduling resolution number 1, please say yea. Yea. It's unanimous. I think it's unanimous. We'll move to number 2 on the list. We had, at my suggestion, I'm going to say, at an earlier date, adopted a resolution saying we would accept sworn, notarized, written statements from parties, so long as no other party made an objection. We tried that, and frankly, it was a bad idea, and I apologize to everyone for having such a bad idea. Of course, a sworn, notarized, written statement, if the person isn't here, is hearsay. It's sworn testimony. The notary swears it. But it's hearsay. And I'm making a resolution, making a motion that we repeal that resolution, And do I have a second?
Second. Sarah Murphy Tammy.
Any further discussion on that? Hearing none, all those in favor of repealing the earlier resolution accepting sworn notarized statements from parties, if there was no objection from another party. If you're in favor of repealing that, say aye or raise your right hand. Either way, it is unanimous, so that is repealed. Let's turn to item number 2 on our list of rules. And let's see if we want to adopt this one. It's entitled Telephone or Online Video Witness Testimony. It reads, the board shall allow hearing witnesses to testify under oath or affirmation by way of telephone voice testimony or by computer, online, visual, and/or voice appearance under oath or affirmation. It shall be the responsibility of the party calling the witness or the non-party witness, if the witness is not called by a party, to ensure that the necessary electronic technological connections are established and functioning properly. I think by allowing people to testify over the telephone after they're sworn over the telephone, or testify over Zoom or YouTube after being sworn in, I think we're allowing those people who have property here and they're in Florida, or they're ill, or they're incapacitated, we're giving them the opportunity. Everyone now has at least a telephone to testify under oath. I think this would certainly speak to the sworn affidavits not being a good idea. Why? If they can't call on the telephone, then their testimony is just, well, we won't have it. But I think this telephone or online video witness testimony under oath, I think it's a good idea for the citizens and for the witnesses that have trouble getting here. So I make a motion that we adopt resolution number 2, telephone or online video witness testimony. Do I have a second?
Second.
Jim
I
Conlon.
have a question on that. Is that online or video testimony now considered hearsay, or is it
No.
hearsay is not applied here?
It's live. It's live enough, so to speak. They're doing it in our courts of law now, during this COVID thing. And my understanding is they're doing it in some criminal matters. They've been doing it with criminal bond hearings that require the defendant to be present. They've been doing that for years, doing it over video conference. So, yes, it's over the telephone or by Zoom and YouTube. Of course, we'd like to have them here, see them eyeball to eyeball. It's just about any other discussion? All those in favor of adopting number 2, the telephone or online video witness testimony, say aye or raise your right hand. And it's unanimous. Let's turn to number 3.
Who seconded it a while ago?
That was Jim Steele.
Yeah.
Number 3, entitled Sworn Affidavits. It reads, introduction of sworn witness affidavits into the record of a board hearing with an affiant of the statement is unavailable for cross-examination under oath or affirmation, and where no hearsay exception for admissibility under the North Carolina Rules of Evidence exists, is discouraged as incompetent evidence. The North Carolina Rules of Evidence, which we're supposed to follow, says unless you've got an exception to the hearsay prohibition, and there are a number of exceptions, I won't go into it, but there are a number. Unless you meet one of the exceptions, hearsay is not competent evidence. Any introduction into the record of such hearsay evidence shall be at the sole discretion of the board. So what I want to say here is, we're not saying we're never ever going to let somebody put a sworn affidavit into evidence, but that's our call. It's discouraged. And I put this in our list of resolutions to put it out there to the public. Don't come expecting you're going to get your sworn affidavit in, because this will put you on notice that you've got a steep hill to climb if you want to do a sworn affidavit and get it into the record. So I'll make a motion that we adopt number 3, the sworn affidavits resolution. Do I have a second?
Do we need to list criteria for when we will accept it? Do we need to make a reference to North Carolina law? I mean, again, this is for clarity. This is trying to be more specific. Do we need for clarity to say, these are the things that we are looking for if you're going to bring this?
I think basically what we're looking for is, you need to meet the rules of evidence.
Right.
If you don't have an exception.
Should we state that?
I do.
Specific. Okay.
Yeah. Let me do it. Have you got your copy?
No, I don't have a
I thought I gave you a copy.
No, sorry.
I am so sorry. I don't know.
You know what, I have an extra copy.
I know I got one here.
Thanks,
Do you have
Sarah.
it?
Thanks, Sarah.
Good to meet you.
Good seeing you.
Okay. Flip over to number 3. I am so sorry. Does everybody else have a copy of these? Okay. Stephen, I got an extra copy. Do you want a
I
copy?
have one at home, I read it, looks good.
All right. And Miss Perry, are you out there?
Yes,
Do you want a copy of these resolutions to be?
I have it.
Very good.
Okay, now I see it. I see it now. Thank you.
You got one, Brandon?
So I've made the motion. I believe Mr. Jim Steele seconded it. Any
I have
further-
a point of information.
Yes.
When it comes to the voting, is discussion of the board, is that majority or is it a certain number, percentage, when you vote on it?
It'd be majority.
Majority?
Yes.
Okay.
The only time we get into the percentage stuff is with a variance, but I've got to have full
All right.
face. I don't know of anything else that. we
It's
like.
okay, I just wondered.
Any further discussion on number 3, the sworn affidavits being discouraged as incompetent evidence? Hearing none, all those in favor of adopting number 3, the sworn affidavits resolution, say aye or raise your right hand.
Aye.
It is unanimous.
Who seconded? Jim?
And Jim Steele, yes. Number 4 is an adjournment time for our meetings and hearings. Our last hearing went to 12:30, and we just can't do that. That's brutal. We're all too tired to be doing the work. It's not fair to the town staff. I approached a number of you individually to get your intake or thoughts on what would be a good firm quitting time for all meetings, so that one of us can leave the house and tell a babysitter or a spouse, well, they can't go any later than such and such. So that'll give you an idea of how potentially late I can be. And after talking to a number of you and asking our planning director what his thoughts would be, he's here with in every one of these hearings. I had people giving times between 9 o'clock and 10 o'clock. Having said that, let me read the resolution. The time is blank, and then let's talk about what we would do to fill in the time. Number 4 is adjournment time for meetings and hearings. The meetings and hearings of the Board of Adjustment shall adjourn no later than approximately 1 hour prior to that time. The board shall discuss and consider whether the business before the board can be concluded completely by that time, or it appears that the current business could not be concluded by that time, and it is therefore advisable for the chair or vice chair to determine the continuation date after hearing scheduled input and concerns from the parties, the witnesses, and board members. The chair or vice chair should make a good faith effort to accommodate the schedule and concerns of all, but the final determination of the continuation date shall rest with the chair or vice chair. Like I said, I got times from people between 9 and 10. I would propose we pick the midpoint 9:30 and just do a motion on that. Is there anyone that's really adamant on something earlier or something late you want to discuss it further? I have no problem if you do. Okay.
Kevin, what is your preference?
He was a
I said 10.
He was a 10 o'clocker.
I could throw in 8:30 and that would like bring the average down.
Yeah.
Let's,
I mean, what, I guess, what's the, what is a reasonable time that if we say this is when we're gonna stop, but yet we can go over, what is, do we, is
the
it a
problem with
half
getting,
an hour, an
the
hour?
problem with getting too early, we for sure want to knock out a variance in one night. It's becoming obvious that on the appeals, if they have an attorney, an appeal with an attorney just takes a long time, and we're never going to get an appeal with an attorney in one meeting. It's just not going to happen. I can see that. But we want to, an appeal without an attorney goes much faster. Don't ask me why. I think we could do a lot of the appeals in one night and not inconvenience the staff and us by having to come back a second time if we pick 9:30. So what we'd end up doing is at 8:30, we'd say, okay, it's an hour before 9:30. Are we confident we can finish this darn thing by 9:30? Or if we have any doubts, let's just stop right now, pick a continuation date and go home. All right, having said that, I'm going to plug in 9:30 and it reads as follows. Number 4, the adjournment time for meetings and hearings. The meetings and hearings of the Board of Adjustment shall adjourn no later than 9:30 p.m., approximately 1 hour prior to 9:30 p.m. The board shall discuss and consider whether the business before the board can be concluded completely by 9:30 p.m. Or it appears that the current business could not be concluded by 9:30 p.m. And it is therefore advisable for the chair or vice chair to determine a continuation date after hearing scheduling any further concerns from the parties, the witnesses, and the board members. The chair or vice chair shall make a good faith effort to accommodate the scheduling concerns of all, but the final determination of the continuation date shall rest with the chair or vice chair. I make a motion, we adopt number 4, the adjournment time. Is there a second?
Second, Lee Rockmore.
We have a second. Any further discussion? All those in favor of adopting resolution number 4, the adjournment time, raise your hand or say aye. Aye. It is unanimous. It is adopted. This goes back, number 5, the board chair and vice chair may make motions. We adopted that a long time ago verbally, but this puts it in the list to be shown to the public, and it reads, the board chair and vice chair may make motions. Pursuant to Town Code Section 16-3.2.5, the board chair or vice chair may take part in all deliberations and vote on all issues. The Town Code already says that. The chair and vice chair shall also be allowed to make motions on any issue or topic that a regular member would be allowed to make. We've already adopted it, but for the sake of form, I'm going to make the motion we adopt number 5. Do I have a second? Dr. Rockamore is second. Any further discussion? All those in favor of adopting resolution number 5 say aye or raise your hand. It is unanimous. And number 6 has some old things and some new things. It's rulings on objections during the hearings. Pursuant to North Carolina General Statute, Section 160D-406D, the board chair or vice chair shall rule on any objection by a party to jurisdictional or evidentiary matters, and the chair or vice chair's rulings may be appealed by a party to the full board. Any board member may ask for clarification or discussion of a ruling by the chair or vice chair, regardless of whether there's been an objection to the chair or vice chair's ruling. After such clarification or discussion, any board member may object to the chair or vice chair's ruling, and the full board shall vote to sustain or overrule the chair or vice chair's ruling. And as a member of the full board, the chair or vice chair shall have a vote, as does any member making an objection to a ruling by the chair or vice chair. A tie vote confirms and sustains the chair or vice chair's ruling. So, in the vote, whether to uphold or the board overrule the chair's ruling, the chair would have a vote in there to make make that clarification. I'm gonna make the motion that we adopt number 6. Is there a second? Sarah Murphy seconds. Any further discussion on objections?
And this would be a majority, in this case, this evening, 4, with Sarah would be 5, but if this is just a majority in this vote,
Yes.
the full board shall vote to sustain.
Every vote we take, except the vote on variance factors, and a variance is a majority. A variance, to pass a variance, we need 4/5. All right, I lost my train of thought. Did we vote on it?
Yeah, second of it.
All those in favor of adopting the rulings on objections number 6, say aye or raise your hand. It is unanimous.
Who
and it
seconded
is
that?
Adopted.
Who seconded
Sarah
that?
Murphy.
Sarah?
I'm going to sign this and date it February 25th, 2021. And I'm going to give it to Mr. Kevin Rothrock and ask him if he'd make some copies and make it available to people that file applications for variances or make appeals, and please give it to our clerk. Thank you very much. Just a couple of things on, a couple of things. Because this is the only time I get you all together, just to make sure everybody's clear. The Blowing Rock Code talks about non-conforming situations, and it talks about non-conforming uses. And it talks about situations and uses. It's obvious that the code is trying to use situation to refer to inanimate things like boundary lines, placement of buildings. And they want to use use to talk about something with an activity. The short-term rental cases we've done, a short-term rental is a use. A variance would be for a situation, an inanimate thing. Unfortunately, just to clue you in, through the Blowing Rock Code, Land Use Code, Chapter 16, they occasionally mix up their use of situation and use, and I want to make you aware of that. Sometimes, there's one ordinance, I can't remember where, they call the same thing a situation and a use in the same darn paragraph. But what they're trying to use is situation to inanimate fixed things like boundary lines and setbacks, and use to talk about activities. I handed out to all of you, to all the board members, let me see if I can find one, something pertaining to variances. It's entitled Some Variance Issues, which would apply in all variance cases, not necessarily the one we have tonight. Did everyone get that? I sent it last night, and I'm sorry to be so late with it, but I wanted to make you aware that there's a lot of nuance to these. And if somebody appeals our decision on a variance here, whether it's the person seeking the variance or the town, we must always remember the town can appeal. Then it's going to go to Boone to Superior Court over there, and a judge over there, a single judge, is going to decide whether we made a mistake or not. And somebody can appeal that up to the North Carolina Court of Appeals in Raleigh. The decisions by the Superior Court judge over there, they're not published like the Court of Appeals. And so if you want to try to flesh out the law and you have questions about what a regulation means or how we should apply it, you're forced to go look to the Court of Appeals opinions on their various cases and try to divine what they think the law is, so we know how to apply the law to our cases. I noted in there that a lot of towns and cities, in their zoning ordinances, they give some commentary as to why we want setbacks, and why we want this, and why we want that, the reason. Blowing Rock doesn't do that, they just state the rules, and that's the end of it. But going through it very briefly, I told you a while back, I would try to act as your attorney, because we don't have our own attorney like the bigger towns and cities do, and the Blowing Rock town attorney is, he's allied and has a conflict because he's allied with a party. So acting as your attorney, I went through some variance case law to try to give you some more idea of how variances are done, and give myself the same idea. We're all learning this as we go. And I noticed in that document I gave you on variance issues that the Court of Appeals, they're very aware of how many opponents there were and how sympathetic the opponents were in the case. And they have noted that neighbor input is, we are allowed, we should consider that. Think what the purpose of the zoning is. You know, zoning is like good manners. It's meant for us all to live more comfortably and amiably with each other, have some distance, have some rules that hopefully make our property ownership smoother and nicer. So if somebody is seeking a variance that the next door neighbor thinks is going to make his life harder, he should be heard and his opinion certainly considered. Some other things I noticed going through a whole lot of Court of Appeals cases and a lot of conditional use permit cases. In a lot of cities and towns, the Board of Adjustment does conditional use permits. We don't here, but they're very similar to variances. And I noticed the Court of Appeals, they're the most comfortable things that have increments, have degrees, like setback. You know, you want to come in to the 12-foot setback, 3 feet, 4 feet, 5 feet. They're paying a lot of, how much grace are you asking for? How much of a favor are you asking for? They pay a good bit of attention to that. And they're much more comfortable with something that has increments, like just a distance from a property line, as opposed to something that you either do it or you don't do it. One of the examples I use is somebody in a single family residential district coming in and say, I want to build a duplex. That's absurd. Totally flies in the face of the zoning. But things that have increments, we can vary. And they repeat time and again. We are allowed to bend the rules and vary the rules a little bit, but we can't break the rules. And boy, it gets into such a gray area. When are you not just bending it a little bit and varying it, but breaking it? Yeah, Jim.
When I read it, it was very subjective. I mean, the whole thing was
It sure is.
is
It's in the
very
eyes of the beholder.
subjective. There was nothing in it that was subjective that you could measure it.
It's tough.
When I went through each paragraph, and as long as it was less than, but when the examples, how big?
Yeah.
How big are your neighbors? Is it 2 blocks or is it 20 blocks? You know, he just said 40 neighbors. Well, that's a lot of neighbors.
Yeah.
But I don't know what he was talking about. So these appeal decisions were very subjective. How do you feel about it? But it did give you wiggle room.
It's tough.
That's what I thought.
It's tough.
It gave you the liberty to have wiggle room in your deliberations.
Yes.
But you better be able to justify it.
Yes.
That's what I got out of that
It's
whole thing.
It was somewhat bad in the Pinehurst case. where somebody, without getting the required variance or permit, just built a 7-foot fence in a spot where the zoning says a fence can be no higher than 3.5 feet. And then they come asking for a variance, and the Court of Appeals says, looking through all the Pinehurst zoning ordinances, Pinehurst takes their appearance very, very, very seriously. And they don't like unattractive things like tall fences, and the board should never even consider this. Oh, no, you're not gonna get a variance for a 7-foot.
Those guys built it without a permit.
And, yeah, they don't like that either. They don't like that either. And every time a Board of Adjustment said, built it without asking permission, no, you created your own hardship. The Board of Appeals backing every time. So anyway, I won't keep going, but I hope that was helpful to you.
I thought it was good. I didn't think that, quite frankly, I thought it was interesting because I didn't really think if you went by your rules, you had any kind of opportunity to wiggle,
Well, there's all sorts of gray area in there,
huh?
all sorts,
Yeah,
you know,
Yeah.
and if nobody appeals, if we're wrong, we're
Yeah.
never called on it. But we need to do the right thing and
Yeah.
follow the law and do every case as though everybody can't wait to appeal what we're doing, get it right. Let me take up one more thing, that I hope will be helpful in what we do here tonight with Ms. Aiken's case. And ordinarily at the time we talk about law pertaining to the case at the end, but let me talk about something with you now before we start, because it's going to affect the way we ask our questions and the entire thrust of the hearing. We've all gotten the staff report from the planning director. Everybody get the staff report? And Ms. Aiken, you should have gotten it at the same time we got it. Did you get that?
Yes, sir.
Okay. In the staff report, I think it was in Mr. Rothrock's part, he says as part of what you're gonna do, and you don't need to say anything to this, let me just go on a minute. He says the existing carport is going to be removed. Well, to keep us on track and so that we don't get distracted, I handed out to everybody a sheet of paper that includes, up towards the top, not at the very top, section 16-8.3 entitled Extension or Enlargement of Non-Conforming Situations. Does everybody have a copy of that? Do you have a copy of that, Kevin? Do you want a
I
copy?
mean, I've got the code, if that's what you're pulling
Yeah.
up. I've got that.
Will you give that to Ms. Aiken?
Excuse me, I can't hear.
Who said that?
Tammy.
I'm sorry. All right, Tammy, are we doing better now?
No,
I can hear fine. I think it was Miss Addison.
this is Mary Addison,
No.
Penny Addison. I just can't hear, it's too low the volume.
Okay.
I've got my iPad turned up as much as I can.
Okay, all right. All right, according to the staff report, there is an existing carport, which is a legal, non-conforming situation. It was built too close to the setback. Well, 16-8.3 entitled Extension or Enlargement of Non-Conforming Situation reads, except as specifically provided in this section, no person may engage in any activity that causes an increase in the extent of non-conformity of a non-conforming situation. In particular, physical alteration of structures or the placement of new structures on open land is unlawful if such activity results in an increase in the total amount of space devoted to a non-conforming use. See, once again, they stick use in there to see the situation, or an increase in non-conformity. If, and we don't know yet, we haven't heard the testimony under oath, but if in fact the presently existing non-conforming situation, the carport, if it is completely removed and taken down to the ground, that would put Miss Aiken in a situation of somebody that came in here with nothing but bare yard. The court would say, the old thing is gone, it has nothing to do with the new thing. So she would be able to present this to us as though the old one, as long as the old one's completely down to the ground, removed, and doesn't exist anymore, she's in the same position she would be as if she came in here and nothing was there, it was just bare ground. Do everybody understand what I'm saying? That is what,
So she loses her grandfather.
No,
She
no.
doesn't lose her grandfather.
No.
If she loses this appeal, she still has her carport. But if she wins her appeal, one of the conditions is it's got to be taken to the ground and completely removed so there's nothing there. There's no longer a non-conforming situation. And, again, a judge or an appellate judge would look at every single word in this, and it's all about extending or enlarging the old thing. Nothing here says you can't tear down the old thing and replace it and try to get a variance in something new.
you can, in section 16(8.3.3), you can tear down an existing structure that's non-conforming and build it right back in the same footprint. No, it cannot be larger in any place that would extend or expand the non-conformity, but you could build it larger in the area that it does not violate the setback
I understand.
for residential purposes. I mean, that's a garage, house, anything associated with residential. Can't do such with other uses.
All right, well, I wanted to mention that so that we kind of had that off our mind. So let's proceed to turn to Ms. Aiken's case. We have a hearing tonight on a variance application from Ms. Patricia Aiken, who is here. The case number is shown on the planning director's staff report. It's variance number 2021-01.
Thank you, Sarah.
Thank you. See you next meeting.
Yes, thank you.
Bye-bye.
And let the record show Sarah Murphy has recused herself from this hearing. We now have 4 board members remaining. Ms. Aiken, I'm looking at your variance application, and the applicant is listed as Sky House LLC. I assume that's your builder.
Yes, it is.
And maybe that's fine, but would you mind becoming the applicant on your own application? And would you-
Absolutely.
May we amend your application to read Patricia Aiken is the applicant?
Yes, that's fine.
Mr. Rothrock, would you amend with your pen or computer that applicant name, please? So she's the applicant here. She's showing as the applicant on your report, on her own application. It was shown as Sky House. You will need, do you have the original piece of paper that she signed here? Would you give it to her? We're going to ask you to strike through Sky House and put your name, and we're going to ask you down at the bottom where it says applicant signature to sign and date your name, so that you are shown as the applicant. And it may be fine to have your builder do the application, but I think it's much more appropriate for you. Really, this is for you, is it not?
It's similar to, applicants, a lot of times are builders for zoning permits, and we issue them in their name. And then whose house is it, we don't say the builder's house. We say it's the owner's house.
Yeah.
And they are on the application, their name. So it's similar to what.
Well, this will get it, at least should be matching what you listed. You have her as the applicant, and if, like I say, if Ms. Aiken doesn't mind, I think we'd be more comfortable with her as the applicant. And Mr. Pell, I assume you're with Sky House.
Yes, sir.
Are you going to present her information for her?
Yeah.
Okay.
Second, do you want me to change the address? Yeah.
Okay, we've got some things to address briefly. This is a variance hearing. To obtain a variance, the applicant must have the vote of 4/5 of our 5-person board. We have 4 members here. That means that to get this variance, Ms. Aiken would have to have a unanimous vote from all 4 of us. And I understand Ms. Aiken and Mr. Rothrock, you are both okay with a 4-person board? You have no objection to that? Okay. Do you have any objection to it? Okay. And Ms. Aiken, the person keeping the minutes of this hearing is an employee of the town. Do you have any problem with that?
I do not.
All right. Mr. Rothrock, I assume you have no objection to
No
your
other
assistant
choice.
keeping the
And
minutes?
she's the usual secretary to the
Okay. Does any member of the board have a conflict of interest in this case that we need to take up? And there's nothing from any member. Has any member had any ex parte conversations about this case that we need to talk about? And as usual, I'll tell you, sometimes we have no choice. Like in the last case where I had 5 or 6 unsolicited emails come to me. You know, we can't help it. People walk up to us and start talking. We're just obligated to say, whoa, wait a minute, I can't discuss that. Let's stop the conversation. No ex parte communications. Everyone said no, including myself. We are allowed to drive by the property in question, to eyeball it. Of course, we're not allowed to stop and chat with anyone, but we are allowed to drive by. I drove by this morning and looked at it. Did anybody else drive by the property? Mr. Jim Steele did, Dr. Rockamore did, Mr. Lance Kent. We've all eyeballed it. Very good. Do we have anyone out in Zoom, or is this Zoom or YouTube?
Zoom, and we've got Denny Addison is online neighbor to the north.
Okay. Denny Addison? Okay. And is Mr. Addison going to be a witness, or does he consider himself a
Miss
party?
Addison,
A witness?
Mrs. Addison.
Mrs. Does she consider herself just a witness that wants to give input, or does she want to be a party?
She does not want to be party.
Okay. Is there anyone else out in Zoom land? Because I'm half blind, so I can't
That's
tell.
just us.
Okay, so we have one additional witness out by Zoom.
Right.
And for the record, I'm going to ask one time, is there anyone that feels like they have standing to come into this case? And to have standing, you'd have to feel like you were going to suffer special damages if the outcome of this case didn't go the way you want it. Last call, anyone feel like they have standing? Very good. Could we please swear all the witnesses?
You want to speak?
No, I don't speak, but stand.
Excuse me?
Yes.
My name is Jim Addison. I guess I have standing because I'm a part owner of the lot next door.
Okay. Are you opposing the application for a variance, Mr. Addison?
No,
Okay.
Do we have to state our position at this point?
No. There are parties. The parties are the critical players in a case. The town is a party, Ms. Aiken is a party, and somebody else that feels like they have a dog in this fight, that they think they're gonna be hurt or injured if this variance is granted. If we determine, yeah, you may suffer special damages, we will let you come in like a three-way lawsuit and be a part of the case and not just a witness. So I'll ask again, does anybody feel like they would suffer harm and suffer special damages, and you want to get into this case as an antagonist? Anybody out there?
Well, I have a question.
Yes.
I'm sorry.
That's all right.
I'm confused.
Okay. What's your,
But do you not invite the remarks of the adjoining owner?
yes.
We were given notice.
Oh, we would love to have your input. The more information we get, the better our decision will be. There's just a difference between people that want to give their input and people that are fighting the variance. Do you see the difference?
Well, that's an awful hard line.
Well, we can solve it with one question. Do you feel like you would suffer damages, and that would be damages pertaining to your property, if this variance was granted?
Well, I would just like to have some input.
Okay, all right. Well, I do need a yes or no answer to, do you feel like you would suffer damages if this variance was granted?
I don't know the terms of the variance.
Fair enough.
Huh?
Fair enough. This is, and I'm speaking with Mrs. Denny Addison,
Right.
Yes,
okay? And the gentleman that just spoke a minute ago, was he Jim Addison?
yes, that's my husband.
Okay, Denny and Jim are the same person.
No,
No.
her name
No.
is Denny,
No.
D-I-N-N-Y.
Explain why?
that piece of property that's next door to this, has three owners. One is my wife, Denny Addison.
Okay,
One is her sister, Lee Mason. And one is a trust, the Marybank Shalander Trust. I am a trustee of that trust.
okay,
My name is Jim Addison.
okay, all right. Now, at this point, Mrs. Denny Anderson wants to be heard, and you, Mr. Jim Addison, at this point, you're gonna want to be heard at some point. Have I got that right?
That could possibly be, yes.
Okay, all right. Well, let's go ahead and swear anybody that thinks they may be a witness. If you change your mind, you don't have to be a witness, but anybody that knows you're gonna be a witness, or you think you may be a witness, we're gonna swear you in now, and Ms. Tammy Bentley is going to do that. Is that correct, sir?
Right. So Tammy's gonna do this, and anyone that's gonna be sworn, you folks, myself, the Addisons, if they wanna speak, will be sworn at this time.
Very good, let's proceed.
Okay, Tammy, go ahead, if we can, I think we can hear you.
Okay. Do you solemnly swear or affirm that the evidence you shall give to this body in this matter being heard shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
I do.
Very good, all right. Ms. Aiken, the way this works is we have the planning director, Mr. Rothrock, kind of present the case, and then he will take any questions you have or we have for him, and then you will present your case. Very good. Mr. Rothrock, tell us about it.
Okay. The variance case number is 2021-01. Applicant is Patricia Aiken. Location is 252 Heather Ridge Lane, and the zoning is R15, single family. Ms. Aiken is requesting a setback variance of 9.1 feet from the 12-foot side property line.
Let me, is it 9.1 or 9 feet 1 inch?
9.1.
So it's 0.1 of a foot,
A tenth.
a tenth. Okay, all right. I'm sorry. Thank you. Go ahead.
It's hard to measure a tenth out there in the field, but yeah, that's just where the math comes to.
Okay.
From the 12-foot side property line setback to build a garage, the closest point of the new proposed garage will be 2 feet 11 inches from the side property line. Property is located at 252 Heather Ridge Lane and is further identified by Watauga County Pen 2817-77-3145. As I mentioned, the property is zoned R15, single family. Ms. Aiken is planning to remove the existing carport and is requesting relief from the side setback of her property to construct a new garage and covered access from the garage to the house. The covered walkway, as proposed, is also shown to encroach a couple of feet into the 12-foot setback. The existing carport is 2 feet 1 inch from the adjacent neighboring property line at its closest point. The proposed garage will be moved off the property line to 2 feet 11 inches at its closest point. The proposed garage is a one-level, 2-car garage with no living space. I'm going to try to pull up this site plan so everybody can see it. And if anybody wants, I do have the laser, if anybody wants to look at that. So if you can see here, if the cursor is following that right there, that 2 feet 1 inch is showing the existing carport edge. And that's at the closest point. Over here it's 3 feet 6 inches off the line. And then the proposed garage, the blue line is indicating the overhang of the new proposed garage. And that is at 2 feet 11 inches. So the variance that they would request is at the closest point, 9.1 feet
Okay.
of variance from the 12-foot setback. Over here is the covered entryway, and you can see where it encroaches as well into the 12-foot setback. Let me go a little bit. This shows a schematic view, a kind of a rendering of the proposed garage when complete. We can go through a couple of these pages if you'd like. Well, as completed, this is how the garage would look finished, bird's eye view. This one does not show the property line. There's an aerial photo here. Shows the existing carport. And I think I have a picture. Let me stop screen share. Well, in your packet that you received, you saw the view of the existing carport, photographs that were presented. I think I've got some in my packet as well, if you'd like those. I don't really have a whole lot more to add. I know the applicant would like to speak to it. But I did get one other email other than Addison's, and I'll pass that down. Judith Allison, they live at 244 Heather Ridge Lane, which should be to the south of Ms. Aiken's property. And it says, for the record, we have no objection to the variance. Patricia has planned the renovation of the home thoughtfully with respect for the environment and surrounding properties. Please let me know if you need any additional information from us.
And what's her last name?
Allison. Judith Allison. And others.
Would you make that email part of the record?
Yes.
And I'll hold my other questions for a while. Have you finished?
Yes, sir.
If we want to look at the pictures that came in our packet,
I'll try.
okay.
I'll try.
Or does Mr. Pell have those as well?
I printed
Yeah.
off what you was emailing.
That'd be fine.
Um,
You want them now, or you want them to go
No,
ahead and do their?
just so at some point we can bring them up. Ms. Aiken, this email is hearsay. Do you have any objection to it being part of the record, part of the file in this case?
I do not.
Mr. Rothrock, let's see what he has to say. Do you have any questions for him?
I have one question.
Yes.
It somewhat has to do with this discussion of non-conforming structure. So when, I know that there was a change in the setback perhaps when this land went into the ETJ, is that correct? My question would be, when the prior owner built this carport, was it non-conforming at that point? Or were the setbacks different that it wasn't?
When this structure was built, it was built in the county, Watauga County.
Mm-hmm.
We didn't take over jurisdiction until 2005, which was brought into the ETJ.
Mm-hmm.
I can't say when it was built. But Watauga County doesn't have zoning. They do have some setback rules now, but I don't know that when this was built, if they had any then. But it would have been under the county's jurisdiction.
Okay, so when the carport is referred to as a non-conforming structure, it's a non-conforming structure to the current zoning, but not what it was when it was built.
It was made non-conforming in 2005. Like, anytime the code goes into effect, the effective date, many things come into non-conformity. Uses, in fact, structures, the way that they're built, and they're not conforming, but they can remain as they are.
Okay, thank you.
Do you have any other questions?
No questions, just something to add to the background that he provided.
Yeah, we're going to want a lot more information. Does any board member have any questions of Mr. Rothrock?
Kevin, does the front corner of the garage, how does it do in terms of setback from the road? Is it 30, does it meet the front setbacks?
Yes.
And
That setback is not 30, that's 12, but the edge of the road
is that considered
is
front
this
of the house, I
line,
assume?
is this line here,
Yeah.
and it's more than 30 feet back.
Okay, thank you. I just couldn't tell.
I've got a,
And do we have any measurements on the current footprint of the carport?
Yes. I mean, the length of it,
The footprint, the square footage.
I mean, we could estimate what it is.
That would be important, I think, looking at the two structures, if we're looking at this, maybe the structure, like square footage of the proposed structure versus the current square footage of the other structure.
Yeah, I don't have any idea.
I think it'd be something certainly put into the facts. Yeah, Mr. Steve?
I was gonna ask, what are the dimensions of your current carport and what is the new garage?
Is that the dimensions on?
Here's the, I can show you the dimensions of the proposed.
Yeah,
I don't see them, Kevin.
I'm showing you right up there on the screen.
What?
Okay.
Oh,
22.
they're not on my paper.
No.
Huh?
Well, the architectural plans were sent to you, but it's,
Yeah, well, I
so
don't have
that dimension, not including the overhang, is 22 by 26.
That's the existing carport.
Say that again,
No.
Kevin?
No, this is the proposed garage is 22 by 26.
By 26? And what's the old one?
I'm gonna say, I'm gonna estimate that at about 18
Okay.
by
So,
22.
so does the existing carport cannot handle 2 cars?
I don't know.
Pardon me?
I don't know.
Well, see, 7 and 7 is 14, 15. 15, it could handle 2 compact cars. But it can't necessarily, you need 18 feet for 2 regular-sized cars.
What was your approximation?
park 'em.
18 by 22?
Without that thing in the center.
Yeah, I would,
Okay, that's just all, I just want to know how much bigger it's going to be, that's all. Okay, thank you.
Mr. Rothrock, I've got a few questions. The covered walkway, do you have an exact measurement of how much it encroaches into the setback?
no. But let me go back to that one site plan again. How wide is that walkway?
I think I scaled it roughly 2 feet at its closest to the property line.
Which is near the, closer to the house?
Well, it's actually right toward at the entrance of the garage.
Okay, oh, the closest point, right.
Yeah,
It's further off as you get closer to the house. So it's what, 6 feet wide? 4 feet wide?
yeah, I think it's 5 feet actually.
5 feet wide, so about 2.5 feet into the setback at this point right here, if you can see my cursor on the screen. That's the closest.
Mr. Pell, before we hear from you, if we have to take a 10-minute break, we will, but try to get us an accurate measurement of how much the walkway is going to encroach into the setback, okay? Let me continue on, Mr. Rothrock. Mr. Rothrock, I've never known you, on behalf of the town, to take a position on a variance. You have every right to be in favor of one or be against it. Do you have a position on this one?
No.
Have you given proper legal notices of this case and this hearing to the public and to everyone else with a legal right to have notice?
Yes.
When was the residence here built?
I don't know.
I can answer that.
Okay. Are you going to testify? Or are you just going to let Mr. Pell do it?
I'm happy to testify.
Okay. Well, let's just chat. When was the house built?
1979.
The setback ordinance, I've pulled out of the code book, and I'm going to hand it to Mr. Rothrock, make sure this this is the setback sheet you're working from, is that correct?
Yes.
Okay, all right. And while you've got it, what ordinance, chapter, section number is that? You want the sheet back?
Article 12,
It's 16.
16-12.4 thing.
Okay.
Yeah, 12.4.
All right, let me get my sheet back.
Oh, you got it written up there. I didn't see that.
And you said this property was taken into the city when?
Into the ETJ in 2005, into the city limits November 2020.
Well, the ETJ is the city. That was 2005.
Right.
Okay.
That became part of the town in 2005?
In the
ETJ,
Became
2005.
part of the ETJ,
In 2005,
2005?
annexed in this past November.
2020.
Yeah.
The area, we did not take over, do we maintain that street? That's a private road, isn't it?
No, we maintain it to the town limits line.
Huh?
We maintain it to the town limits line. As it goes on around the corner by Earl Ford's, where it's gravel, we do not maintain that. It's outside of town.
We don't maintain that road, do we?
Yes,
Including in
Heather
front of
Ridge-
Ford's? It's not a paved road.
we maintain it to the city limits line. Once it goes around the corner by Earl Ford's and turns to gravel, we do not maintain that.
Well, you do not.
No,
And this property doesn't have a gravel road in front of it.
right. We maintain it to her house. The property, the city limits line goes around her property now.
Oh, it does? Okay.
Anything further? Anything further?
I'm all done.
Yeah, okay. After hearing our questions, Ms. Aiken, do you have any questions now you want to ask Mr. Rothrock?
No?
Okay, very good. Thank you, Mr. Rothrock. Mr. Pell, you're going to present the facts of what Ms. Aiken wants to do?
Yeah, it kind of would just expound on the photos that were sent in the packet or emailed.
If you would, it looks like you're building onto the house itself too, is that right?
That's right, yeah, it's an extensive, yeah, about the whole scope of the project.
Well, don't get carried away.
No, I'll give you the basic scope of it, which would be an addition renovation of the existing house, which is enlarging the footprint of the existing house within the setbacks and the confines of the property. And then we're redoing a retaining wall. We're gonna do a new retaining wall to add to the yard. And then with that would come where the carport is. That was needing to be turned into a garage. You can see in the pictures that there's a large oak tree right beside the carport, and actually the carport was kind of built around it. It's cut into the overhang of the carport. So in order to save the tree, not have to cut anything down, you can kind of see from where the existing carport footprint is, and we've moved that footprint back from the road and back, towards into the field of the property.
So you're asking, Aiken is asking for a 9.1 foot variance into the 12-foot setback for the garage, is that correct?
Yes, sir.
And Mr. Rothrock said the dimensions of the proposed new garage are 22 feet by 26 feet, is that correct?
That is.
Do you have an exact measurement of the old carport?
I don't. I could, if there's a ruler in here, I can go to my truck and get a scale. I could give you. Okay.
But that's all right. He estimated approximately 18 by 22. Does that sound pretty close to you?
Yeah.
22 by 26.
That's the garage, that's the new one.
That's a new one, yeah.
The old carport.
The old one.
Yeah, we're doing.
Going to the covered walkway, what would be, if we were talking just a variance for the covered walkway alone, what's the variance there? How close is it? How far does it go into the setback?
I would estimate that's around 2 to 2.5 feet at its furthest point encroaching the setback, and then it angles back into contact with the house within the setback.
All right, so you're gonna have to live with this figure if we grant this variance. So for the covered walkway, you would need how much variance if you're gonna place it in the place you proposed?
Thanks. It is 10 feet. It's 5 feet. So it's 2 feet where with the covered walkway that meets the proposed garage.
So if you got a variance of 2 feet into the 12-foot for the covered walkway, it would work for you.
Mm-hmm.
Okay, all right. Could you,
I think there's a fact, anyway. Who owns the land right behind this carport?
The Addisons.
Huh?
The Addisons.
Right behind it? I was led to believe it was deeded to the state.
No. Behind their property on the lower side, yes, but behind this garage is to the north.
is this the laser pointer? Which way do you?
Oh, you mean behind the house is,
Am I doing it?
Kevin, is it behind the carport
See where that,
Is
see where
owned
the
by-
north arrow is?
right there?
That's the Addison's property.
Okay, which is the one that's deeded to the state?
It's
It's
this
not
way.
that.
Here.
It's that way.
No, the guy next door owns that.
Was that I thought that was a laser pointer.
It is.
All right, can you enlarge it again?
Okay, going that way?
Yeah, enlarge it.
There's the Addison's property, and down off into the gorge this way.
Oh, I see, okay. Because there's, all right.
Can you enlarge it back? That's my fault. Good, okay. All right, turning to you, Mr. Pell, or Ms. Aiken. Again, let me get it clear. Behind the existing carport, behind where you're proposing to put a garage, who owns that property there where the pointer is?
The Addison group that he described,
Okay.
owned by
And
three
that's
people.
Jim and Denny?
It's separate.
Not sure what you mean by behind.
The side,
Well, if the front of the garage is on the driveway side, it would be,
The co-
It would be on the-
There's a common boundary.
It would be on the, what would, north side?
On the north side.
Yes, on the north side.
Okay. Mr. Pell or Ms. Aiken, what is the grade like behind the existing carport, proposed garage, right behind it? What's the grade like there?
You know, to the property line, you might have 3 to 4 feet of rise from the back of the carport to the property line.
Does the grade drop off?
Yes.
Yeah, so, you know, from back of carport, property line, you might have a 3 to 4 foot difference in elevation. Does that make sense?
Okay, let's kind of take it slow and easy. Right behind the existing carport, is there any flat ground or does it immediately slope down
It's immediately sloping.
from the rear of the existing carport? And so from the rear of the proposed garage, again, would the grade right behind it fall off?
Not right behind it, no.
How much flat ground would there be behind it?
2 to 2.5 feet.
And of course, the actual property line would be right there at that, couple of feet out from the existing carport. Would that be correct?
Mm-hmm.
And is there any vegetation on Ms. Aiken's property behind the existing carport? Or is it just bare ground before you get to the property line with the Addisons?
Yeah, there's a good coverage of rhododendron, you know, all pretty much along the entire property line.
And what kind of plants are they?
Rhododendron,
Okay. And they're on Miss Aiken's property or they're over on the Addisons?
both.
Okay.
Addison's fully, you know, wooded, and then there's a row of rhododendrons that actually even straddle the property line.
Okay.
And then she's got some out past that as along the property line as well.
Okay. I hate to hop around. Let me go back to you, Mr. Rothrock. You got a response. I think you said you did proper notices. Did that include letters to all the property owners, the adjacent property owners?
Yes, sir.
And did you get any response from anyone besides Judith Allison?
No.
How about these people that are waiting on the Zoom?
Yes.
Did they
Yes.
talk to you?
Yeah, I've talked to them several times.
Okay, so
That's why they're on here.
Jim and Denny Addison and Judith Allison, have you heard from anybody else?
No.
Okay. Did we have,
For your information, when I was there today, the people next door on the east side, or south side, I was parked in the driveway, I was gonna walk down,
yes,
and they said, "What are you doing here?" I said, "I came to look at this garage." And they said, "Oh, yeah, we're in favor of that." That's what they told me, and that's all I said. I left,
okay,
just FYI.
okay. All right. Mr. Rothrock or Ms. Aiken, do you have anything to say pursuant to what Mr. Steele just said?
The only thing I would say, and I don't know if it's exactly pursuant to that, is that the shape of these lots being narrow and very long is, I have not gone out and measured all of the other houses on there, but I think but I'm pretty sure from looking at them, that the majority of them are closer to the property line than 12 feet, just because the nature of how this obviously was developed makes it difficult to, I mean, with the fact that it falls down and it's narrow, that we're not asking for something that is not consistent with, this, that's there, if that makes sense.
I understand. Can somebody get this picture up on the big screen for us, the picture of the carpool?
I'll try. I'm the only one that can. Here we go. I got that one.
Can you get this? That's the good one. Great, that's fantastic.
Surprised myself.
Mr. Pell, how would you describe, well, let me back up. Show me how that laser pointer works here. Which end is it gonna? As far as parking and turning cars around, is there a whole lot of space over here for that?
Not at all.
Okay. And I noticed that when I went this morning, I was shocked at how tight it is. How difficult is it to turn cars around in there? And Ms. Aiken, you may be the better person to answer this. As far as what parking area and turnaround area you have, would you call it ample, tight, difficult? Please put it in your own words. How would you describe the parking and ability to turn around in your own vehicular area?
I have no problem whatsoever turning around. With the area that's given, and I think that it's been drawn such that you could turn around with, even with a little bit deeper, garage. There is, obviously not ample extra parking for guests. But the turnaround is adequate.
When I went by this morning, I noticed a trailer looked like it was being used as a dumpster in the middle of it. Can you get your car in there with that trailer there?
I think there was one of your trucks, the struggles. A car can get in.
I think you could. You might, with the current area, you're making a couple turns like that.
Okay. To pull straight into your driveway and turn around and drive straight back out, is it necessary to pull into the garage? Pull into the carpool?
To turn, yes, it would be.
And that would be because you don't have a whole lot of room over here.
Correct. There are quite a few large trees, and it's also sloping. It's, my house sits further down.
Yes.
Yeah, so in that area, the road's much higher than that area. It kind of slopes straight down, so it's kind of locks you into your options.
Would you call the whole lot that you're on, Ms. Aiken, would you call it narrow, wide? How would you characterize it?
We'd call it quite narrow.
Any board member have any question for Mr. Pell or Ms. Aiken?
I have a question for clarification.
Sure.
What relevance does the current carport, which became a non-conforming situation as of 2005, have to the application for a variance today? In other words, if the carport was not there, it's going to be torn down. Would this application for a variance stand on its own?
Well, that's what we're going to determine.
Okay.
Yeah. And that brings a good question. Mr. Rothrock has said in his staff report that the existing carport is going to be, see how he just said removed. Is that true? It's going to be completely removed?
Yeah, I mean, that if this was to be approved, then that would be the plan. It would be removed, and we would go with the new footprint.
And the carport is sitting on ground or gravel, that's not concrete slab, is it?
That's correct, yeah, it's just gravel.
How high will the new roof line be compared to the carport?
I think they're actually similar. It's pretty much like that, only the new structure is turned this way. So it's the same gable, only it switches like this, and the two-car garage goes into the side of it.
Was that a 412 pitch?
Yeah,
What is the new one?
something close to that.
The new one's much bigger than that. It's almost a 1012. I'll bet.
So you're looking at
Huh?
18 foot 8 inches, approximately to grade, tall.
So that pitch there is greater than this one. Yes.
Yes.
Any other questions from the board?
Mr. Pell, can you measured the garage, can you give us a measurement on the carport using that?
For the height?
No, the length of the.
Okay, yes, we can verify. Let me see if I can get this on a quarter-inch scale. Here's existing carport. So we've got 26 by 18.
Okay. So basically, it sounds like the width is staying the same, the depth is changing?
Yeah.
The
It's
depth is
gonna-
coming towards the front,
Correct.
so it doesn't change the relationship to the setback?
It does in the sense of it's less encroaching on the setback. than
That's because
what-
you're moving it further away.
Right, we're bringing it back in towards the property.
Right, okay. So the width is the same, it's just the depth as it comes towards the front of the garage, which does not impact the setback, and it's moving further away from the road, which takes it less, okay.
But the dimensions of the proposed garage are 22 by 26. We have that straight.
What the dimensions I just stated were for the existing carport.
Right, and the new garage
And
would
the
be
new,
22 by 26. I think we've heard.
I cannot get to this page. Here we go.
22. By 26. The measurement that I provided for the existing carport is the outside of the roof line.
Okay.
I'll have to look and see if I can, to give you the same, and what I gave you for the new proposed garage was the footprint. So it didn't take into consideration
At the ground.
the overhang. So I could look at an elevation and get you that overhang.
I think we have enough. Do we have enough information on the dimensions?
Is there any provision for a room above this garage? Could a room be added?
Not as drawn. I mean, maybe you could put storage, I think, long-term storage, but not a heated or conditioned space. As drawn and proposed.
Any other questions? All right, Mr. Jim Addison and Miss Denny Addison, it's time for us to hear from you. Which one of you wants to speak first?
My question, did I hear the height of the garage or not? In comparison to the carport?
At its highest point, it was, Mr. Pell, 18 feet?
Yeah, that's off of a grade provided on the drawing. I don't know if that grade's exact.
I'm sorry, how does that compare to the height of the carport?
I would say that the carport, yeah, I think that we're at 9 feet to the,
About 14.
yeah, so I was thinking, it's about 14. You've got an additional 4 feet, 4.5 feet of height.
Jim, are you able to hear that?
Yeah, I think you said additional 4.5 feet of height.
Right, it's
Correct.
about 14 feet now.
Yeah.
All right, Mr. Jim Addison, Miss Denny Addison, which one of you wants to go first and speak with us?
You better let her speak.
This is Jim Addison. I really don't have anything to say. Well, can I ask a couple of questions first?
Wait a minute, Mr. Addison. Now, if you're gonna be a witness, you tell us stuff. Do you have an opinion on whether this variance should be granted? Let me ask you that.
Maybe
Well,
he
we'd
wants to
like
ask.
to finish talking to you first.
Okay,
I'm
well,
asking a question.
that's where we are. Which one of you wants to speak your mind to us first? Mr. Denny?
Well,
Miss Denny
we've got
Addison?
some questions. We've got a couple of questions.
All right, go ahead. Which one of you? Let's take you one at a time, though. Miss, you're Denny Addison, correct?
That's right.
D-I-N.
That's Jimmy. Jimmy is going to speak now.
Jim is going to speak.
Is
He
the
started
variance
speaking.
actually needed here? Is the structure as it existing is coming down and a new one is being constructed, is that correct?
That is what they're proposing, to tear down the existing carport and in almost the same footprint place, but not quite, put up a garage that will have walls and sides. That is correct. And the place where the existing carport is now is too close to the property line to meet the zoning requirements. So the existing carport, when this property came into the city, it was grandfathered. The carport didn't meet the zoning setback requirements, but it was grandfathered. It didn't have to be torn down. Now they want to tear it down and put up a real garage in just about the same spot, and that will also be much closer to the property line, presumably it's your property line as well, than the rules allow. So they want a waiver, a variance to get within that setback, closer than the law allows. That's what they're asking.
I thought I heard someone early in the conversation say that the Blowing Rock statute allows you to tear down the structure and build another one back in the same non-conforming place. Did I mishear that?
No, you did. You heard that correctly. The problem is they want to make it a much nicer
And they're missing.
structure. They're gonna slightly move the location, and they're gonna have a much nicer garage. It's not gonna be just a carport open at the sides. It's gonna be a real garage. So
That changes the nature of the structure from a carport to a garage and closes it.
I I see, I understand,
Yeah.
okay, that's fine. No, I'm fine.
Hello, this is Denny.
How do you spell Denny, Miss Addison? D-I-N-N
It's
what?
a, it's a nickname.
Well, what's your,
It's D-I-N-N-Y.
all right, well, that's what we'll call you in our
My given
paperwork.
name is Mary Quinn.
Okay, do you want to speak with us?
I do. If you grant this variance, I would like for you to, I guess I would like for you to specify, even though it's in the code, most probably, that there can be no expansion vertically or in any direction. That's one item, and the other is that one story only, not a space that can be finished above it. And somehow this, it gets recorded in the courthouse, I'm hoping, is that right? So that, for instance, if Patricia sells the house down the road, that the buyer would have notice that they cannot change the configuration of the garage.
They would have to, if they were going to change the garage, they'd have to get a building permit. And this Miss Aiken's house is in the town of Blowing Rock. And if somebody was going to change the garage, they would have to go to the planning office and ask for a building permit. The building permit people would come out and look at it, and they would go, wait a minute, there's some issues here because this was built with a variance. So it would be caught that way as long as the new owner followed the law and went to get a building permit. Does that make sense?
Well, it makes sense, but it would be nice if a buyer would be put on notice so they don't can't come back and plead the case of ignorance. So there's no way it's put in the chain of title.
And it may be.
It should be. It will be. And we record a variance, so it goes with it runs with the land, because we don't keep building permits beyond 6 years. Nobody does.
All right, so it will be in the chain of title.
I am told that, but we can make that a condition that if the town of Blowing Rock attorney doesn't put into the land records this variance and the terms of the variance, that Ms. Aiken will have to do it at her own expense. She'll have to have a lawyer file it.
I would like that, just to protect our property in the future.
Okay. Is there anything else you want to say?
That's it.
Okay, and just to make clear, one more time, you are an owner of the property behind the carport. Is that correct?
That's right. That's right.
Okay.
And the property in the valley below these houses was given by our family a year ago
Okay.
to the Trust for Public Land, so it will be preserved.
Okay. So Miss Addison, as long as the variance is recorded in the land records of Watauga County, either by the town attorney, or if he fails to do it by Miss Aiken's expense, as long as that is done, do you have any objection to a garage?
No, just, again, no expansion, no finishing of the attic area. And then put in the land records, and I'm happy to share the cost of that.
Okay. All right, does anyone else want to speak to this case and be heard? Anyone else?
I think something needs to be clarified. She said that she doesn't want any expansion of the current size, but it would be 4 to 4.5 feet higher, and it would be deeper.
She means not larger than the structure as proposed.
You know,
Oh, as-
right,
Oh,
right.
okay, all right.
And she doesn't want somebody living over it, obviously.
Could be used for storage, but that's attic.
Is that allowed, Ken?
Yeah, what?
No living space is what she was talking about.
Unfinished, yeah.
Right.
Okay, all right, we're ready to start working on our findings of
I
fact.
have a couple more
Oh,
questions.
I'm sorry.
Okay. One thing is, could the garage be made slightly smaller so it basically conforms to the current side, except for the depth of the carport?
Well, we've got it as small as we can, even based off of her car, so you can see, we've even got her model car in there to make sure that the door would swing open and not hit the car, and also she could get out of the car with another vehicle in there and not, hit doors. So it's been thought out to, be the smallest footprint, that we could get by with, she still be able to operate through there safely.
And in the current house, it looks like there's a side entrance that was the current, I guess, did you use that or did you not use that?
There's currently a side entrance into part of that, into the part that jets out. It's the side entrance is being moved
Right.
Right,
with the renovation. I currently do not use that, no.
And what is the
Because
purpose?
there's no easy way to walk that way.
So,
Let me,
and what is the purpose of the covered walkway?
To haul groceries, out of the elements,
Yeah, well, and that last picture shows too, the terrain through there, it's already got a bridge, a permanent walking bridge to get across some of the contours of the grade as you get to that door on the house.
the walkway and the side entrance go into the laundry room with the thought of muddy boots, muddy paws, tile floor, that type of thing.
And you understand if the variance were to be granted, you cannot enclose that it's.
Mhm.
Yes,
Yeah.
yes, yes.
If
only
you
they
spun the,
reconstructed it in such a way.
if you spun the cable
Got it
roof
out.
the other way,
Moved it out, so.
couldn't you pick up some extra space between the lot line and the garage without having an overhang on that side?
Well, it comes into the driveway too, and getting the car pulled in,
Yeah.
pulled out.
I'm just asking the question,
Oh, yeah, I'm just giving you my.
because it's non-conforming, again, but you could pick up almost 1.5 feet if you didn't have an overhang on the back side. And you'd have to switch the gable,
Exactly.
rather than having it out this way, keep it the way it is, so you just have the gutters there. It's something to think about.
All right, ready for findings of
Okay, thanks.
fact? Thank you. I handed out earlier a form, which I hope will help us go through this in an organized fashion. I've been speaking all night. Does somebody want to get us started on the findings of fact? Any volunteers? Hearing none. Fact number one, the applicant is Patricia Aiken. The owner of the property in question is Patricia Aiken. The address of the property in question is 252 Heather Ridge Lane in Blowing Rock. And the county PIN number is 2817-77-3145-000. The property is zone R15. The applicant wants to do the following, which would violate zoning regulations and which would require a variance. Wants to build a garage and a covered walkway, both of which would intrude into the 12-foot setback from the side property line. The new garage would be 2 feet and 11 inches from the property line. By the way, if I misspeak a fact, please stop me before I get too far in that. That goes for you, Mr. Rothrock, and you, Ms. Aiken, and Mr. Pell, if I misspeak, because I make a lot of mistakes. The new garage would be 2 feet and 11 inches from the property line, needing a 9.1 foot variance. The covered walkway, which would run from the house residence to the proposed garage, would also encroach in the 12-foot setback by 2 feet. By 2 feet. The Blowing Rock zoning ordinance section, which is at issue here, and which stands in the applicant's way, is 16-12.4. And put into words, the ordinance requires a 12-foot setback from the property line. Number 7, there are not other properties standing to come into this case. The applicant did provide drawings or sketches or plans or pictures illustrating what the applicant wants to do. The town of Blowing Rock has provided and given all necessary legal notices of this case in this hearing. There was proper notice of this case in hearing given to all property owners with property abutting the parcel of land which is at issue here, and proper notice was given to any other persons entitled to receive notice. The applicant did receive a copy of the planning director's staff report prior to the hearing. There were witnesses in the hearing who are neighboring property owners, and facts given by such witnesses were Mr. Jim Addison had questions of the board. But no facts to convey. Mrs. Denny Addison. Excuse me, let me back up. Mr. Jim Addison, what is your address there? What's your house number on Heather Ridge?
It's vacant.
What is it?
Property's vacant.
Don't even know that.
It's a vacant lot.
B11.
I'm saying
I don't
you,
know I don't know the street.
that's all right. I'm saying you own the vacant lot next door. Ms. Denny Addison said she had no opposition to the requested variance. So long as the variance was recorded in the land records of Watauga County. What the applicant is proposing,
Sir,
yes,
there were two other things that I asked for. One was that it specifically stated that there cannot be an expansion
You
in
are-
any direction
you are,
and no finishing.
you are correct. Let
sections of the
me,
house.
let me go back, I'm sorry. After the wording about recording the land record, in the land records of Watauga County, let me continue, and if the Blowing Rock town attorney fails to record the variance, Patricia Aiken should record the variance herself. Fair enough on that? Additionally, there should be no expansion of the garage and no living area in or on the top of the garage. Ms. Anderson, did I address it with those words?
Yes,
Okay, I want to cover everything that you told us, and I think I did, and I'm sorry I stopped too soon on the first round. Okay.
well, instead of saying, I want it to stay in an unfinished, it's not to be used as living space, in other words.
Okay, let me say, no living area in or on the top of the garage. Well, I said no living area. What else would you want?
Well, I just had envisioned an unfinished space, but that's all. That's fine.
We can do that, and
Not heated or cooled.
the top area should remain,
Shall,
Well,
shall.
shall remain forever unfinished. How about that?
That's fine.
All right. Moving on, the evidentiary hearing has not been closed, in case we had questions, and I have a question of Mr. Rothrock. Mr. Rothrock, in your opinion, would the proposed variance cause any impairment to emergency vehicles such as fire trucks and ambulances?
No,
And in your opinion, would what the applicant is proposing create a fire hazard?
no, there's a stipulation that if it's in the building code, that if it's less than 3 feet to the property line, that it have a certain type of insulation and finish,
Well, that
1 hour rated, but it'll have to
the
be.
building inspector will take care of this. Okay. And in your opinion, is what the applicant proposing, would it block or impede visibility on any street or highway?
No,
So let me back up, and fact number 12 was the two witnesses, Mr. Jim and Mrs. Jenny Addison. Fact number 13, what the applicant is proposing would not impair emergency vehicles such as fire trucks and ambulances. Fact 14, what the applicant is proposing would not create a fire hazard. Fact 15, what the applicant is proposing would not block or impede visibility on any street or highway. And number 16 is for us to conclude, and what the applicant is proposing would or would not be contrary to public health and safety, and the description of the way the proposal is, and the description of the proposal. Bear with me a minute. I wrote this today and I can't understand my own phrasing. Would not be contrary to public health or safety. Stop. And that's the end of number 16. What the applicant is proposing would not be contrary to public health or safety. Other facts we should include are, at the time of this hearing, there is a lawful non-conforming carport on the property. It's located in almost the same location where the proposed new garage would be located. The existing carport is 2 feet and 1 inch from the property line.
What are you on, 17?
17, yes.
The fact of the matter is, he's reducing the size of the non-conformance.
Yes. And let's make that,
But it's still the
we don't know-
non-conformance.
Yeah, we still
But,
don't know the actually.
but he's reducing it.
No, because the actual, the numbers he gave us did not.
Well, if he does the gables like
'Cause the
I'm
other-
talking,
yeah, 'cause
he
the
pick
other-
up another foot.
Yeah, yeah, so we don't
So,
know that, so.
When he
it's-
builds, if he redesigns it a little, the
Yeah.
building by turning it, I'm just saying, the facts are that he's reducing the
encroachment.
encroachment,
Encroachment, yeah.
period,
And enlarging the footprint a little bit.
whether it's 1 inch or a foot.
I am over on the back of the sheet, and we got a number of facts to do over there, including the dimensions, we'll get to that. Number 18, the residence on this property was built in 1979. Fact 19, the dimensions at the ground of the proposed garage are 22 feet by 26 feet. Is that approximate, or we know for sure it's right dead on 22 by 26 at the ground? Is that approximate?
Yeah, I mean, I would give it a tolerance of
Let's say approximate. And the height,
approximate.
at the highest point on the proposed garage is approximately 18 feet.
18.
Do we really need to put the dimensions of the old carport, do you think?
Yeah, I think for us to understand that what Jim brought up about the size being somewhat comparable.
All right. Fact 20, the dimensions of the existing carport measured at the ground are approximately 18 by 26.
That was the overhang.
Mr. Pell, is it 18 by 26 including the overhang, or is that at the ground? The ground
Yeah,
floor?
that, I believe that is, that is including the overhang of the existing carport.
The dimensions of the existing carport measured at the roof overhang are approximately 18 feet by 26 feet. back 21, the existing carport, the existing non-conforming carport will be completely removed if this variance is granted. The representative of the town of Blowing Rock, planning director, Kevin Rothrock, has no position, one way or the other, as to whether this variance should be granted. Let's go ahead and say this property is taken into the Blowing Rock extraterritorial jurisdiction in 2005 and taken, what would you call it? Fully into Blowing Rock or into, what do you call the regular?
What was your question?
Incorporated.
They were in the ETJ. Once you're in the regular,
They were annexed in,
okay,
I mean,
and annexed fully into Blowing Rock in 2020. Anyone have any other facts?
Couple of questions. How wide is the walkway?
Approximately 5 feet.
Could that be made narrower?
Probably.
Because I assume that's what, a 3-foot door?
Yeah, both of those are gonna be 3 foot wide
And then,
at the garage.
and if you did an outswing door instead of an in-swing door, you could actually maybe cut a little bit on the width of the garage instead of making an in-swing door, which would help her with her car.
Well, the outswing doors, you know, they'll, if that design, it'll whip it open and bust it, you know, the first gust when you're opening it and you got your hands full or whatever. So that's why we typically do it.
And it goes both ways.
Yeah.
Any other questions?
Mr. Springs? Does the email from the Allisons count as a witness on number 12?
No. It's gonna be a part of the record. But we can't call. That's not sworn, it's hearsay. Fellow board members, any other facts?
So just to clarify, it's walkway right now is 5 feet?
Yeah, approximately. I think that's.
That
what
doesn't include we're not talking about the overhang, but if we say narrowed it to 4 feet or,
It's still in.
it's still, yeah, but it's less.
I would move it. Yeah, if you're trying to make it more narrow, my personal opinion, I would move it out of the setback. I mean,
4 feet's a pretty wide space. I mean, I have a stairway.
if their architect designed it for a certain situation, and if that became an issue, you might just move it instead of making it smaller than what it needs to be.
Yeah, it makes it less of an issue if we do that.
That's what I'm saying, I would
Yeah.
move it.
So we could actually, then maybe we talk about two thoughts. One is the garage, one is the walkway.
What do you think, Mr. Bell? Could you make it 4 feet instead of 5?
Well, it's, okay.
The door is it's a 3-foot door.
You've got a 3/0 door, you've got, so it's actually, as drawn, 4.5 feet, 4.5 feet wide.
Is there a roof overhang to the walkway?
Let's see if I can pick up on an elevation for that.
Is it an A-line roof?
Yeah, it's gonna be a little simple, gable.
So the dimensions you're giving us, is that at the overhang of the roof or is it on the ground?
Here we go, gotcha.
Not shown on that.
It's got 1 foot 4 inch overhang, as drawn.
Okay, so you said it was 5 feet wide. Are you talking?
Well, it's 4, yeah, so post to post, outside of post to outside of post, of the support is 4.5 feet to scale. Then it's got a 312 gable roof, with a 1 foot 4 inch overhang, and that's a level measure.
Fact number 24, I'm writing the width of the walkway at the ground, measured at the ground, is 4 feet, what was it?
4 feet 6 inches. And so, and to answer your question about making it narrower, with that being the outside of the 6x6 post, that inside dimension is 3.5 feet.
But still wider than the width of the doorway.
Yeah, it's wider than the width of the door by 6 inches. So you got 3 inches and 3 inches on each side of the door for your trim and your,
Thank you.
and it would still be able to, take on groceries and all that stuff.
Any other questions? All right, let's vote on our facts. Let's go ahead and close the evidentiary hearing. I make a motion that we close the evidentiary hearing and we move on to law. My motion is to close the evidentiary hearing. That's the motion. Is there a second?
I second.
There's a second from Lance Campbell. Any further discussion on the facts? All in favor of closing the evidentiary factual hearing, raise your hand or say aye. It is unanimous. And we move to the conclusions of law. Conclusion of law number 1. Based upon the evidence presented and the facts shown above, the Board of Adjustment, it's either going to be finds or does not find substantial, material, and competent evidence exists to conclude that in this case, unnecessary hardship would result from the strict application of the regulation. And before we do a motion on that, let's discuss that a little bit, and I'll kick off the discussion. This is a fairly unique lot. I was shocked at how tight the vehicular area was in this yard. Looking at all these architectural drawings, I had the impression of this huge expanse, and I was rather skeptical of this whole thing. But looking down into the parking and car area from the street, it is a tight, narrow lot. Anyway, any other comments from any?
when I looked at it, I thought, there's nothing wrong with a carport as long as you're a summer resident. But if you're a full-time resident and you live up here during the winter, like this one, I could understand why she would want to have a garage. And while I understand that, when I looked around, I didn't see another place to put it, a garage, where she could move it and therefore be non-conforming. I didn't see one on the property.
Right.
So
You know-
I guess if I had, I could say it could be a hardship not having a closed-in garage.
Well,
If I
think
lived there.
having a garage here, I think would be a reasonable use of your property.
I also,
I-
yeah,
Most of us here in Blowing Rock suffer from lack of parking and tight driveways and so forth, but this is one of the worst I've seen. It's tight.
and the other thing I'm sort of, yeah, I just think it's a hardship for her not, I would think for her, it would be a hardship not having a garage. Now,
Well, I'm gonna add, at number one, we haven't voted on it yet, but I'm gonna,
could she live there without it? Of course, but
I'm gonna add the property here is very tight as regards the vehicular parking and turnaround area. The lot, the overall lot is fairly unique in being quite narrow. So let me make a motion that based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case unnecessary hardship would result from the strict application of the regulation. The property here is very tight as regards the vehicular parking and turnaround area. The overall lot is fairly unique in being,
The garage doesn't change any of that. Actually, if you want to look at it, the garage makes it worse because it actually comes more into the property.
yeah, but it's, I think a reasonable desire to have a garage, that's,
I understand, but I mean, saying it because it's narrow, it's an issue, because what you're actually gonna do is you're gonna take up more space of this footprint than you did of the old. So you're actually making it tighter in terms of vehicular access.
right. Well,
Oh, yeah.
we've stopped the facts, so we have to stop the discussion. Now it's,
It's just, you're taking up more footprint into the lot.
right.
We're not probably making a huge amount of difference in the setback issue. But the big issue is, if you can make the issue that it's a narrow lot as a reason to do this,
Yes.
this garage, as it is proposed, actually makes it potentially more difficult, more tight, because it comes another,
I agree, but I think,
Six, yeah.
but I think the trade-off in having a garage and walkway that keeps her out of the snow and the rain is worth the trade-off. Do you think we should add some wording or change some wording in the?
I'm just thinking about the reasoning as to what we're using for the garage. Now, are we gonna talk about the garage and walkway as a unit?
Yeah.
Or are we gonna, okay,
It's so much easier.
okay. Because I think, can we mitigate? I mean, can we make recommendations about possible changes? to it, or we can accept it as is, as strong, as
We,
proposed.
we can make conditions, we can go through the 4 factors and vote on those. And then we can put conditions on it.
Okay.
Do you want to, as we do the 4 factors, work
I think
conditions?
I think we need to separate the 2 structures, I think,
Do you want to do the 4 factors
yeah.
and either approve it or turn it down? And if we approve it, then go to conditions?
Okay.
All right. Well, let me make a motion that, number 1, based upon the evidence presented in the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case unnecessary hardship would result from a strict application of the regulation. The property here is very tight as regards the vehicular parking and turnaround area, and the overall lot is fairly unique in being quite narrow. I make a motion that we find that conclusion of law. Is there a second?
I make a second to that motion.
Lance Campbell seconds. Any further discussion on that, the first factor we have to? Fine. All right, all in favor of the conclusion is just stated, finding, in this case, she has met the requirements for the first factor. All those in favor say aye or raise your hand. And the vote was unanimous. Moving to number 2, which reads, based upon the evidence presented in the facts shown above, the Board of Adjustment either finds or does not find substantial material and competent evidence exists to conclude that in this case, the hardship results from conditions that are peculiar to the property. And I'm going to add some language to that, but let's divide this into 2 parts. And let's see if we find or do not find that she has met this requirement, that in this case the hardship results from conditions that are peculiar to the property, either finds or not finds. I'll word the motion in that we find that she's met it, and if somebody thinks she hasn't, of course, they'll vote no. And then let's add some more language to it if we find that she's met it, and do it in 2 steps. So based upon the evidence presented in the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case the hardship results from conditions that are peculiar to the party. Although all those that find that she has met this requirement either say aye or raise
Did you
your
say,
hand.
you said party or property?
Peculiar to the property. Yeah. All those that find that she has met this requirement, raise your hand or say aye.
You need a second?
I thought, did I not do the same?
No.
Yeah, Lance.
No,
I'm
that
sorry,
was the
that was
last one.
Lance.
That was the first one.
Do I have a second to that? This is factor number 2.
Lance,
I'll second.
Okay.
Lance Campbell seconds the motion. Any further discussion on factor 2? All those that find that the applicant has met the requirement that in this case the hardship results from conditions peculiar to the property, say aye or raise your hand. And the vote there is unanimous. The second part, I'll throw mine in and then you're welcome to throw yours. I'm kind of repeating. Well, I will repeat. I would add the same language I did in factor 1. The property here is very tight as regards the vehicular parking and turnaround area, and the overall lot is fairly unique in being quite narrow. I would duplicate that language. Does anyone have any other language you want to add to factor 2?
I find some comfort in the fact that this proposal is not an extension or an expansion or an increase in the non-conforming use. It's actually a decrement in the trespass into the setback. So I take comfort in that.
I guess I'm trying to decide where we could work that in. I think we'd have to put that in the facts. Do you want to go back and reopen the factual section and add that?
I think it's important, so I would add it there.
Just to make sure we've done it properly, I move that we go back to the findings of fact and reopen the hearing by the board on that. Do I have a second? Second. We have a second from Dr. Rockamore, and all those in favor of going back to the facts and reopening that. For Mr. Campbell to make an addition, say aye. Aye, it's unanimous on that. So we're at fact number 25, and Mr. Campbell, what would you add as a fact at number 25?
I would say that the proposed variance does not increase or enlarge or extend the trespass into the setback. In fact, it is a smaller trespass into that 12-foot setback,
I think you need to qualify that specifically for the garage,
just for the garage.
because the walkway is a significant, is a whole different issue. I think it needs to relate just to the garage.
The proposed variance does not enlarge or increase the encroachment into the setback.
And in fact,
By-
decrements the encroachment
Well,
existing.
we don't know because we don't know about the overhang stuff. Okay, we're comparing overhang versus no overhang.
So it does not increase the encroachment
It's not significantly, that is significant.
into the setback by the new garage, and in fact, is slightly less,
Maybe.
yes,
Maybe slightly worse.
is, okay.
Maybe, because Mr. Pell wasn't able to give us.
What's that again?
Mr. Pell wasn't able to give us the full dimension, so we weren't comparing apples and apples.
Then compared with the existing carport. Okay. Do you want to add anything else?
That's great.
I move that we add the fact number 25 that we have just articulated to our findings of fact.
You want to read it? You want to read it?
Sure, sure. The proposed variance does not enlarge or increase the encroachment into the setback by the new garage. And in fact, it may be slightly less than compared with the existing carport. And so we have, I make the motion that we add those. Do we have a second?
A second.
And Dr. Moore seconds that. All those in favor of adding that fact number 25 to our findings of fact, say aye if you agree to add it. Aye. So it is added to the facts. So we return to the conclusions of law. And somebody refresh my memory. Have we voted on number 2 yet? Factor number 2.
Voted on number 2, but you didn't vote on the second part you were writing an
Okay.
additional.
All right, that's correct. On the typed part, we found she's met the hardship, the hardship results from conditions peculiar to the property. I propose that we add the exact same language. I added at number 1, the property here is very tight as regards the vehicular parking and turnaround area, and the overall lot is fairly unique and being quite narrow. I propose we add that at number 2. I think it fits. Does anyone want to add any other language to number 2? All right, I make a motion, we add that same language that we added in number 1, which I just read. That's my motion. Is there a second?
I second Lance Campbell, Danny.
All right, Mr. Campbell and Dr. Rockamore seconded at the same time. We'll send Mr. Campbell beat Dr. Rockamore to the punch. He's the second. All those in favor of adding the language I just stated, say aye or raise your hand.
Aye.
And that is unanimous. Factor number 3, based upon the evidence presented in the fact shown above, the Board of Adjustment either finds or does not find substantial material and competent evidence exists to conclude that in this case the hardship did not result from actions taken by the property owner. And I would add that the residents here as built was not cited in its location by the applicant. And the applicant is forced to deal with the topography and siting as she found it when she bought the property. Does anyone want to add any more language to factor 3? I make a motion that we do find that there is substantial material competent evidence exists to conclude that in this case the hardship did not result from actions taken by the property owner. The residence here was built, as built, was not cited in its location by the applicant, and the applicant is forced to deal with the topography and siting as she found it when she bought the property. All those in favor that she's met this factor in number, do I have a second? I'm sorry, I keep forgetting my second. Is there a second to that motion?
I'll second it.
Dr. Rockamore seconds it. Any further discussion on factor 3? All those in favor of finding that she has met the requirements of factor 3, say aye or raise your hand. And that is unanimous. Factor 4, based upon the evidence presented and the facts shown above, the Board of Adjustment either finds or does not find substantial material and competent evidence exists to conclude that in this case the requested variance is consistent with the spirit, the purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. Does anyone want to add any language to it?
When do we talk about conditions?
Number, I think
Not
number
yet.
5.
Okay, all right.
So I make a motion that she has met the requirements, but that we find substantial material and competent evidence exists to conclude that in this case the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. I move that we find she's met that requirement. Is there a second?
Second.
Dr.
A second.
Dr. Rockamore seconds. All those in favor of finding that she's met the requirement of number 4 is just read. either say aye or raise your hand. And that is unanimous. Now, number 5, before I say we're going to grant the variance, let's talk about additional conditions ordered by the board that are mandatory for the applicant to follow if the applicant is to receive the variance. And I would hear from anyone on proposed mandatory conditions. Dr. Rockwell.
I would like to see, I mean, as I understand it, the current walkway is 4 feet 6 inches.
Yes.
The doorway is 3 feet, 3 feet, 30. If we reduce the walkway width by a foot, we also reduce the intrusion into that without substantially impacting the ability of the applicant to access the house.
So put it into a, phrase it as a requirement.
Okay, let's reduce the width of the walkway from the current 4 foot 6 inch to 3 foot 6 inch.
He wants to reduce
Reduce.
the non-conformance in that area.
That will reduce the non-conformity in that area going between the garage and the house.
I think the 4 foot 6 was outside of post to outside of post, so your free space inside of that pathway would have to be minus 6 by 6, minus 6 by 6, so your open area is 3 foot 6. As it's currently drawn, outside dimension on that is taken from the outside of the support post to outside support post.
Okay. So what's the interior dimension if you
3
move?
foot 6.
Okay, that should be adequate. 42 inches should be fine in terms of.
And that's what it's drawn as, is having 3 foot 6 in the clear from inside of post to inside of post, leaving 3 inches and 3 inches on each side of the 3-0 door.
And how can it be 4 foot 6 inches?
To the outside.
You got
The
6
post
by
is
6.
6-inch post on
The
the
post is
inside.
6 by 6.
Opposed to,
He's he's adding that to the actual.
so 3 foot plus 12 inches is 4 feet. So where's the additional 6 inches?
No, the outside to outside is 4 foot 6. Inside clear space is 3
Okay,
foot
well,
6.
okay, if we reduce that to say 32 inches, or, again, we're just trying to reduce the encroachment into the setback.
Mhm.
And with the door's 3 feet, I mean, you've got to go through 3 feet, so theoretically, it could be only 3 feet. Clear space between the posts.
Is there a building code on that?
Yeah, I mean, this isn't, it's not ADA, but you would not have the ability to make that walkway ADA in the future for aging in place if you were to take it smaller than what it currently is. At least just get a wheelchair or a walker or whatever through that access door.
Well, actually, you can take a wheelchair through a 3 foot space.
Yeah, and I'm just talking, you can take it, but you gotta have certain radiuses to turn them and
Well,
all that.
Well, the radius occurs when you go into the door, the house. And actually,
If that's a condition, we all vote on that condition, so we'll move on.
So if you feel like you need it, would you articulate one more time? What would
Okay.
the condition be?
Okay, let's figure out so that the clear space between the post is consistent with 3 feet with the door, 36 inches. That reduces the impact into the space, into the setback by less.
Why don't we articulate it in terms of,
Do we need to give a reason, or we just make a condition?
no, we can, if it's a reasonable condition, I don't see anything unreasonable about it. Mr. Pell said the encroachment into the setback was 2 feet. Is that right, Mr. Pell? By the covered walkway?
And actually it's there at the garage, and then as it goes back towards the house, it becomes less.
Well,
No, he said it was 2 feet at the garage.
That's what I said. As
And
it
by
goes
the
back to
house, by the time you get to the house, you're at inches.
Right, exactly.
well, what is,
Okay.
how much encroachment are you trying to get?
Well, what we can reduce, as long as it does not impact, and again, the ADA is, I think, 3 feet. So I think we're still maintaining that as long as so what we've done is we've taken out another probably 6 to 8 inches of encroachment into the setback.
Actually, it would
It'd
be
be
half that.
Half that.
It'd be about 3 inches, you'd say.
No, 6 inches. You take 6 inches at the
So
garage.
right now, we're at 3'6" as it is, and that allows for that door to be installed and the post to be up against the wall, and those posts are butted up against that, and that allows you to take and remove the door or put it back in without having to change and alter the structure.
So at the door, you have, if the post is, say, edge to edge of the door, which is 2 feet.
No, that's the opening of the door, and then you'd have, I mean, within, I would say that if we have to, like, try to get to 3 inches, we would want to probably try to redesign this.
And it would become less of an issue with the variance. I mean, that's
Or,
not.
or we could frame it out of square a little bit, and if,
Well, you could phrase it as, he's got to get the intrusion by the walkway reduced from 2 feet to 1.5 feet, and let him figure it out.
Yeah.
You want to do it that way? Are you comfortable with the 6 inch?
Yeah. I mean, I think anything that, again, it's important that, I think that we try to be as compliant with the code as we can. And clearly, like you said, and as Kevin's talked, this could be redesigned to go actually into the front where those windows are theoretically.
Well, let's
that's,
let's just articulate it that way.
Okay.
The condition is that the encroachment
for the
by
walkway.
the covered walkway be reduced from 2 feet to no more than 1.5 feet, and just let him figure it
Okay,
out.
okay. That's
So,
good. And it can be done. I mean, physically, it can be done.
of course it can. So we have a condition here. The additional condition is the encroachment by the proposed covered walkway must be no more than 1 foot 6 inches. Must be no more than 1 feet, 1 foot 6 inches, and let him figure it out.
Okay. Thank you.
Are there any other conditions anyone wants to add? Hearing none, I move that we accept the conclusions of law, and we include in our conclusions of law the requirement, the mandatory condition that the encroachment by, say the encroachment into the 12-foot setback by the proposed covered walkway must be no more than 1 foot 6 inches. And then this decision is going to be effective upon filing with the clerk. I move that we accept those conclusions of law. Do I have a second? Second by Dr. Nakamura.
Hold on a minute before you vote.
All right.
The conditions that were specific from Ms. Addison were that it be recorded, that it not be living space above the garage, and it not be larger than it was proposed.
she said, I don't want it enlarged, and I think she was talking about just the use, not the dimensions. But, I'm glad you mentioned that, because,
You used them, they became facts of what was discussed, but if you wanted to use those as conditions, because I think those.
thank you, you're exactly right. You're exactly right, and getting old here. Let's go back to the additional conditions. And the first condition was the encroachment by the covered walkway is no more than 1 foot 6 inch.
Right.
Second condition,
Recorded. Variance be recorded.
Variance would be recorded.
okay.
Not made larger.
Condition 2, the variance must be recorded in the Watauga County land records. And if the town of Blowing Rock attorney does not record the variance, the applicant must do it. Condition number 3, the area of the new garage. Let me reword that. No part of the new garage is to be used for living area and in the area in and above the garage must forever remain unfinished. I think I got it.
Okay.
Thank you. Thank you for reminding me of that, Mr. Marshall. Does anyone else notice anything I've forgotten? That's a pretty big error. I apologize to you. All right, let me go back to my motion that we adopt the conclusions of law and the mandatory conditions. 3 conditions which we added. I've noted that the decision is effective upon filing with our clerk. And now that I've added this language, I'll need a second because we've enlarged what we're voting on. Mr. Jim Steele, seconds. Any further discussion? All those in favor of granting the variance and adopting the conclusions of law, adopting the 3 mandatory conditions, and granting the variance, all in favor of that, raise your hand and say aye.
Aye.
And that vote is unanimous. And does anyone have anything else for this board? Any member? All right. I move that we conclude this meeting.
Just the benediction. That's
of the,
it.
Blowing Rock Board of Adjustment. Do I have a second that we conclude this hearing?
Second.
There we go. All in favor of concluding this hearing and this night, say aye or raise your hand. That's unanimous. Thank you very much, folks.